Richard, are we ever going to overturn the NFA? Opinion.
Not in my lifetime.
Really? Do you think?
Do you see how fast this is all moving?
We are the Arms Attorneys. Today we are talking about the Made in Texas Suppressor case. The Fifth Circuit has just issued an opinion last week. We're going to talk through what has been happening with trying to take down the NFA. Is this specific case dead? And how are we ever going to get there? But before we begin, show your support for the Second Amendment by hitting the like button.
And we're talking about Paxton v. Dettelbach. This is the Made in Texas Suppressor case. This comes on a line of legislative attempts to, kind of get our way around the NFA, the Commerce Clause, by essentially legislating that, hey, guess what? We don't think those laws should touch suppressors. We saw this in Kansas. Didn't work out well for those folks. We saw it in Montana. It fell just short because they upheld it on Commerce Clause grounds. They didn't argue the Second Amendment. So, three times the charm, right? Texas, we tried to follow in their footsteps and correct the wrongs of the past, and we haven't made a whole lot of progress. And the court has found, the state of Texas, these individual plaintiffs do not have standing, but the case isn't dead.
Is it dead? So we had individuals and we had the state of Texas, and both sued the federal government and said, we want to make suppressors without getting a tax stamp because the NFA is for stupid jerks. And
that's the legal term.
That's the legal term. And we have this issue of standing. Can you bring the lawsuit? Have you suffered an injury in fact? And so we've got two separate analyses. We've got the people and we've got the state of Texas. Basically, and a long story short, and I don't know, they may be right about this, but all the courts are saying, everybody's saying that
they out here saying
that the state can't just legislate its way into standing. This isn't a real injury on behalf of the state of Texas. It's wholly derivative from other people's Second Amendment rights, etc., etc. I don't like it, but there's probably a legal argument there that's sufficient enough to support that. However, what about those people, Richard, who said, I want to make a suppressor and I'm not allowed
and I want it now.
Federal government daddy says that I can't have it yet. So what about them? Why don't they have injury? Why don't they have standing according to the Fifth Circuit?
Yeah, and to just look at the logistics of this law just a little bit. Essentially what we did is we didn't decriminalize suppressors under Texas law. We also created a cause of action for folks who said, hey, guess what? I want to manufacture a suppressor here in the state of Texas made of wholly Texas parts. Maybe there's significant parts. Stamp it, made in Texas. We don't intend these things to enter the stream of commerce. And, we, learning from our mistakes, how the law was executed in Kansas, how it was executed in Montana, we gave the Attorney General the authority to sue on behalf of these individuals who were going to try to build suppressors, manufacture suppressors without pre-authorization from the ATF, without going through the hoops of the National Firearms Act, obtaining the tax stamp. And so when they are, saying, hey, I want to build these things, they would notify the Attorney General. The Attorney General would sue on their behalf. All these complaints got wrapped up, and ultimately they failed in the district court. The district court said, hey, you don't have standing. Now we're in the Fifth Circuit Court of Appeals. We're in front of a panel, and they say, hey, guess what? You did not articulate the imminent harm for these individuals. First, they say state of Texas, just like Emily said. You don't have any standing. You're quasi-sovereignty, take it somewhere else. But for these individuals, basically, you wrote your declarations wrong.
Right. So the individuals are trying to get standing by essentially saying, I am going to be imminently harmed, right? I intend to build a suppressor, and I cannot do so without being prosecuted by the federal government, and so I need your help. Court system to tell me that, the government's enjoined from enforcing this particular law against me. However, here is what the Fifth Circuit says. They say that those declarations were not good enough for a couple of reasons. Reason number one, that these people had to essentially say, not only am I building a suppressor, but I'm building a suppressor and I am not going to get a tax stamp. Because if you don't say that, well, you could go ahead and build you haven't established any potential injury at all, because you could go ahead and build that suppressor. You just got to get your tax stamp too. And you didn't specify.
Yeah, and that's kind of
Chicken shit.
Yeah, that's the legal term. Because, when courts want to find their way out of having to decide a controversy, the fallback is standing. They try to find a wiggle room of,
Yeah.
hey, is there any reason why we don't even have to look at this thing?
Right.
And that's where they go. But it's not the end of the case. And it's been widely reported this case is dead. It is not. It's not dead yet.
It is not dead yet. Although I will say there is one
To
other
quote Monty
thing.
Python.
You're not going to get me on board with Monty Python, Richard. So there is one other thing that they say in the standing argument that I do think is interesting, which is not only, well, you didn't say you were going to get a tax stamp, but also like basically you don't say when the government's going to come after you, so it's not imminent yet, which is just
Yeah.
stupid.
Yeah, I
Again,
don't buy that
stupid.
because we have a line of cases saying any criminal law in the books, the threat of prosecution is real and imminent.
Yes. However, no, it is not dead yet because, I mean, step one, I suppose, and I would imagine they are going to petition for en banc rehearing, which we talk about relatively often on this channel. So
Yeah.
what does that mean?
Yeah, for whenever you're suing, you lose, or maybe you appeal to a higher court, especially when it comes to our circuit courts of appeals. They have tons of judges on these circuit courts. They're not going to every judge look at every single case, so they'll assign a panel. Sometimes it's 3 judges, sometimes it's more than that, and they are going to do this kind of initial screening and see, hey, did the lower court get it right? That's really what we have right now. We have a panel who said you don't have standing. The trial court got it right, but the logistical step after that, or the practical step after that, is saying, hey, guess what? I got assigned 3 random judges who are not faithfully, possibly, interpreting the law, and I would like a second go at this.
Right. I want the whole shebang reevaluating this
Yeah.
case, which
Well, think about bump stocks. That's how it happened in bump stocks.
that's how it happened in bump stocks. So, and you and I may disagree here. I don't know that they grant en banc rehearing, and I'll tell you why. Because they didn't reach the merits of this case. They didn't reach New York State versus Bruin. They didn't reach Commerce Clause. And it is potentially easy enough to correct the standing issue with a brand new spanking lawsuit, but potentially easy enough when you discount all of the time and attorney's fees and everything that it takes to get there, and years, right? Because this law was passed in 2019.
Yeah.
And here we are 5 years later. It's just now getting to an intermediate appellate court on a standing issue because that's just the way the justice system works. But all of that to say, I don't think they grant it. Or do you disagree?
Yeah, I think that there's a couple of maneuvers, and it really is going to depend. I mean, if this gathers the attention of more of the judges in the Fifth Circuit, like I said, we kind of had this issue come up with bump stocks. They were initially shut down on a panel en banc, granted relief. And so, I think there's always, I'm a glass half full kind of guy.
But the bump stock issue was a real winner.
Yeah, it really was. And
It was a real winner. We said it from the beginning. This one, I think they got to go back and revise their declarations and try all over again.
yeah, but we, and hopefully if it doesn't get resolved here, again, another lawsuit, not ideal, less suboptimal, as they say. But, we have a show watcher up in Montana, connected him with the, attorneys for the Attorney General's office. Maybe we can get some better declarations.
That would be lovely.
But I mean, that's, a small thing that we can do to maybe advance liberty here in the state of Texas. Maybe it's one of those things that shuts down the NFA.
All right, so I think very last thing, Richard, are we ever going to overturn the NFA? Opinion.
Not in my lifetime.
Really? Do you think?
Do you see how fast this is all moving?
You're a young man, Richard. See, I think yes. And I think that suppressors are
I think that's low-hanging fruit.
low-hanging fruit.
Yeah.
And I think that we have now, not on this case, not on Paxton versus Settlebach.
Yeah.
However,
Are you about to channel Alex Jones in 1776?
no.
But we hope you enjoy this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment for us below. Until next time, we're the Armed Attorneys.